thank you very much for joining us for today's webinar. The session is going to be recorded, and as usual, we'll send around the recording afterwards so that you've all got a copy, can share it with colleagues, etc. So today we're going to be doing a bit of a deep dive into the changes under the Data Use and Access Act 2025 and providing a summary of the key updates for businesses and organisations to be aware of. For those of you that I've not met previously, I'm Hannah Pettit and I'm an associate in the Ashford's data protection team. And I'm also joined by Charlotte Kingman, another associate in the data protection team. So to run you quickly through the agenda for today, we'll start with a quick introduction to the Data Use and Access Act. We'll have a quick look at the timeline for the changes coming into force. And then Charlotte and I will divide up the key changes to data protection law and dive into those in a bit more detail. And then at the end, we'll give a really quick summary on some of those wider changes under the Act. Won't spend too much time on those though, because the key purpose of today is really to look at how data protection law is changing. So we've closely been following the progress of the Data Use and Access Bill as it passes through Parliament. So it's been a bit of back and forth between the House of Commons and the House of Lords, but the bill finally received Royal Assent on the 19th of June, then becoming the Data Use and Access Act 2025. Now, the legislation is also abbreviated to the DUA Act. So if Charlotte or I refer to DUA Act, we are talking about the Data Use and Access Act, exactly the same thing. So the DUA Act reforms UK data protection law. And it does that by updating particular provisions within these three key pieces of legislation on the slide. So UK GDPR, the Data Protection Act 2018, and the Privacy and Electronic Communications Regulation, so PECA. PECA being the legislation that governs things like electronic marketing, cookies, tracking technologies. So importantly, the fundamental principles and concepts under UK data protection law aren't actually changing. So, roles of controller and processor, the requirement for data controllers to provide a privacy notice when they start processing personal data, the requirement for a controller and a processor to have processing provisions in place in the contract between them, and those particular processing provisions obviously being set out in Article 28 of the GDPR. All of these sort of routine tasks that a privacy professional deals with, none of those are changing. But instead, what the reforms do, they are a package of discrete and targeted amendments, which are very much aimed at promoting innovation and addressing advances in technology. So, timing for these changes, most of the changes are actually going to be brought into effect by secondary legislation. So what that means is that we don't, the changes we're about to run through, they aren't actually applicable from day one. The timeframes for them coming into force are 2 months from Royal Assent, so August this year, 6 months from Royal Assent, so the next phase will come into force in December this year, and then we're expecting the final set of amendments to come into force 12 months after Royal Assent, so that'll be next June 2026. That said, there are a handful of provisions which have kicked in from day one, but the only real provision of note that has kicked in straight away is a change in the scope of the search requirements for a data controller when they receive a subject access request. So changing that search requirement to a reasonable and proportionate search. But Charlotte will be running through that one in a bit more detail. And I'll hand over to Charlotte now, who will give you a run through of our first set of changes to data protection law.
Thanks, Hannah. Oh, I'm just going to let my slide catch up. Bear with me a second. So the first significant change is around the legitimate interests lawful basis. So most of you will be aware that you need to have a lawful basis for processing personal data under the UK GDPR. And previously there's 6 lawful grounds that you might rely on, one of those being legitimate interests, and that was a very commonly relied on lawful basis. Others include things like consent and a legal obligation, which I'm sure you'll be aware of. So what the Act does is it introduces a new lawful ground for processing personal data, allowing businesses a bit more flexibility for use of data around things like crime prevention, disclosure for purposes of public interest tasks, safeguarding of vulnerable individuals, responding to emergencies, and assisting bodies with delivery of public interest tasks. Previously, most organisations would have relied on the legitimate interest lawful basis to process data under these headings, whereas now they have categorised these into law, and they've also removed the requirement to undertake a legitimate impact assessment in respect of these types of processing activities. So when you use information for these new recognised legitimate interests, it removes that need for you to balance the impact on those individuals whose data you're using against the benefits arising from that use. And that used to be the aspect of undertaking that impact assessment and looking at those processing activities. So the hope is that it will make this process a little bit more streamlined for organisations who are processing data in these ways. The processing must still be necessary, and a lot of the other principles under the GDPR do still apply, but removing the requirement for an impact assessment does recognise the societal benefit of processing data in these ways and the potential negative impact of any delays that could be caused if an organisation is trying to undertake an impact assessment. You know, things like crime prevention, time very much can be of the essence. This is going to be particularly relevant for organisations which are public authorities or public bodies, or organisations that have a direct relationship with those types of public authorities and public bodies as well, and share data between them. So if you do fall into that category, this is worth looking into in a little bit more detail. As Hannah mentioned, we are doing a sort of general overview of the key changes under the new Act, rather than you know, very detailed analysis of every single change that is taking place. The next area of interest is the purpose limitation. So under the UK GDPR, the purpose limitation principle ensures that individuals' personal data is only used for the purpose for which it was collected. There are a couple of exceptions generally to this, that if the reuse is consistent with the original purpose and the data subject would reasonably expect their information to be used in that way, then you can use the data for that purpose, or if the individual gives their consent for a new use, or if the processing is in public interest. That was the position as we know it. The amendment here aims to clarify the circumstances in which further processing or data reuse is compatible with the original purpose. So again, this amendment is really tailored towards adding sort of clarity and confirmation for organisations around how and when they use data and for what processing activities. It does this by inserting a new annex into the new GDPR, into the UK GDPR, which provides a list of reuses that businesses can assume are compatible with the original purpose when relying on this principle. So, for example, this might be when a company may wish to disclose personal data for crime prevention purposes. And I've popped the list on the slide here. We won't run through all of these in detail today just because of time, but you can see the categories that they do sort of fall into. Most of these provisions were already set out in ICO guidance. So again, this is an area where I wouldn't say there's a significant change in the sort of practical application, but it does codify the approach now into the legislation. And like I mentioned, hopefully this streamlines the process for organisations. 3 areas that we're going to run through relatively quickly. They may not all be relevant to every organisation on the call today, but the first is the processing of children's data. So if you are an organisation that provides online services that are likely to be accessed by children, there are some changes that are building upon the existing legislation that is set out in the UK GDPR. Essentially, if you provide an online service that's likely to be used by children, the DOA Act explicitly requires you to take their needs into account when deciding how to use their personal data. It requires these services to take into account the children's higher protection matters, and this is now something that's specified in the UK GDPR. And that's when you're designing your processing activities and thinking about how you're delivering services to children. These matters include things like how best to protect and support children when using your services, the fact that children might be less aware of the risks and consequences associated with online services and the processing of their data, And an important factor around the fact that children have different needs depending on what age and stage they're at. Whilst this is now specifically requiring organisations to think about these aspects, it doesn't change the position largely from where we were before, because this was something that was already set out in the age appropriate design code, or known as the children's code. So if you are an organisation that processes children's data, hopefully none of this is new to you, and it hopefully is something that you're already doing. We have previously done a webinar discussing the children's code, so if it's something that's applicable to you, it's worth visiting our website to have a look at that. Hannah briefly mentioned data subject access requests. So again, you'll probably be familiar with the concept of subject access requests. This is where individuals can request copies of the data or information that you hold about them. Previously, when the GDPR first came into force, this was an area that was seen as quite cumbersome for organisations in terms of identifying the data that you had, collating that information, liaising with the data subject. The amendment now makes it clear that you only have to make reasonable and proportionate searches when someone asks for access to their personal information. And hopefully this gives organisations the confidence that once they've carried out proportionate checks and searches, that you have met your obligation, your legal obligation in this area. The previous law didn't explicitly state that searches needed to be reasonable and proportionate, although this was something that was discussed and established in case law. So again, it's not a huge change from where we were, but it is a positive one in that it's adding a proportionality requirement into the legislation itself, which hopefully gives organisations a little bit of comfort. The other area is the timeframes around data subject access requests. So previously, organisations had 1 month to respond to a subject access request, and the clock started as soon as the request was received, subject to a few limitations. But the ICO guidance allowed for organisations to stop the clock where they needed clarification from a data subject around what information they were requesting, or if they needed to confirm somebody's identity. This again has now been codified into the law, so the 1 month time frame can be paused pending those clarifications and confirmations. So again, something that was part of ICO guidance has now come into the new Act. And once an organisation has the information that they need, the clock then continues, as sort of was the previous ICO guidance. In terms of actions off the back of this, we would say review your procedure for dealing with data subject access requests, include provision for requesting further information if you don't already have that, and obviously where it's applicable and appropriate to do so. The next change is data subject complaints. So there's a new requirement on controllers to deal with all data complaints raised by individuals about the handling of their personal data, not just those connected with data subject rights like access requests. So if you don't already do this, the Act requires you to take steps to help people who want to make a complaint about how you use their personal data. An easy way to do this would be something like an electronic complaints form or an automated system allowing them to raise a complaint with you. Organisations also need to acknowledge complaints within 30 days and respond to them without undue delay. So here we would say consider your current complaints procedure, whether this allows for complaints relating to the use and handling of data. If not, do think about this area and how you can update that process, how you can allow individuals that right, as well as ensuring that you have procedures internally to deal with these types of complaints. That might be upskilling relevant teams who deal with complaints, sort of complaints handling teams, or it might be just making sure that you've got a good level of communication between your DPO or your risk teams and your complaints teams, and that they understand the process here and the timescales, etc. As Hannah mentioned, there are some changes to PECA. So these are the Privacy and Electronic Communications regulations. There's 3 changes under PECA that I'm going to talk about. So the first being soft opt-in rules. This again is only relevant to some organisations on the webinar today. This is a specific change relating to charities in the UK. So bit of background, the soft opt-in rule means that organisations can send certain marketing communications to customers who've purchased something from them previously or provided goods or services, and you're sending communications that relate to similar goods or services. Generally speaking, it doesn't apply to prospective customers or new contacts, and previously it didn't apply to non-commercial promotions, and that included charity fundraising or political campaigning. The Act now allows UK charities to send marketing emails and texts to data subjects where they've shown an interest in that charitable work, or material for fundraising, that type of thing. So those charities no longer need explicit consent. So it's softened the rules slightly for UK charities in this area. People do need to be able to opt out of receiving these messages. Same sort of rules as the soft opt-in rules that apply generally across the board. And they do need to have the option to opt out at any time after receiving communications. Just moving down to the cookie compliance, again, something that most businesses will be aware of, particularly given various updates in this area over the last few years. Cookie compliance, generally speaking, relates to your website and your website compliance. It requires businesses to show and to gain cookie consent from users for all non-essential cookies that are deployed on a website when a user lands on a web page. There are now some changes to these rules which allow the setting of additional types of cookies without the need for this explicit consent. There's two areas where this applies: cookies that are used for statistical purposes and for improving the functionality of the website. So this isn't all cookies. So for most organizations, your cookie banner might not change, but there might be some where actually you can deploy these statistical cookies or the functionality cookies on your website, and you wouldn't need to necessarily collect consent before doing that. Additionally, the Act also grants the Secretary of State the power to amend or introduce new exceptions under this area through secondary legislation, which again Hannah sort of mentioned, following consultation with both the ICO and interested groups. So hopefully this will streamline the process a little bit for updating things like cookie requirements going forwards. So I think this is an area where it's probably one to watch, see what happens in the next sort of 12 months, if there's any updates in this area, because it may mean that you do need to speak to web developers or IT teams to identify the relevant cookies that you've got on your website, and whether or not they fall into these categories and whether or not you need to be collecting consent for them. And finally, liability. So the previous position under PECA was that fines were capped at £500,000, so £500,000. This has now been increased to meet the levels set out in the UK GDPR, which, as most of you will know, are £17.5 million or 4% of global turnover. So this is a fairly big shift and significantly increasing liability for companies. This is relevant, as I've already mentioned, things like cookie compliance falls under PECA, but also marketing communications. So this is an area where if you are sending marketing communications, you do use cookies, do make sure that you are complying with the law, because the increased fines do mean that you are open to a larger financial penalty if you fall short of the regulations. It's also an area where we do see the ICO fines. The ICO does take interest in this area and they do fine companies quite regularly. So it will be interesting to see if the increases change the way that they've dealt with this previously. But it's an area that's actively monitored, and we're going to be watching this space quite closely over the next sort of 6 to 12 months and see how this is impacted. In terms of actions, I would take it upon yourselves to visit your websites, check your cookie compliance, and think about your marketing strategy. Speak to your marketing teams, make sure you're meeting those regulations so that you don't fall short and potentially face a very large fine. I'm going to hand back over to Hannah, who's going to talk through some of the wider changes.
Thanks very much, Charlotte. So first of all, I want to have a little look at international transfers. So it's worth noting that the UK's adequacy status, which it was granted by the EU, it was due for a review this summer, and the EU actually pushed that back until December this year. And ultimately that's because they want to watch and see how the UK data protection reforms that we're currently talking about, wait and see how those play out before it makes a final decision about whether it's going to be renewing those adequacy decisions for us. What the UK adequacy decisions do is they allow the free flow of personal data from the EU to the UK without additional safeguards. And ultimately, if the European Commission decide that UK data protection law is now departing quite significantly from the EU position, actually it would be completely sort of a plausible conclusion that the European Commission would revoke those adequacy decisions. The positive thing is, though, the reforms that we're talking about, you'll probably have noticed, they're not hugely significant. You know, they're very focused, discrete amendments to kind of deal with things that were maybe already addressed in guidance, or where there's an actual need for a change for innovation or technological development. So actually, the reforms aren't that kind of wholesale shift in a regime. And as a result, we're hopeful that the adequacy decisions will be renewed in December. So that's the first sort of point on international transfers. If people had any questions around actually how are the reforms going to impact our adequacy status, I think our feeling is it's probably not going to, but you know, let's wait and see in December and see what happens. I'm then going to turn and look at the reforms to international transfers under the DUA Act and how these will impact your business and how you assess your international transfers. Next slide, please, Charlotte. Thank you. So as a quick recap, current rules for international transfers, and just to note, these rules that I'm just setting out, they aren't changing under the new law. So first of all, we've got adequacy decisions. If the location you're sending personal data to has an adequacy decision, great, you can send personal data there without any further safeguards. Secondly, if you want to send personal data outside of a location that is adequate, you need to implement appropriate safeguards. So that's something like standard contractual clauses. And alongside that, you need to complete a transfer risk assessment to confirm that once you've put those appropriate safeguards in place, data is going to continue to be subject to the right level of protection. And then thirdly, you've also got data protection exceptions, which are sort of limited exceptions that allow us to export personal data internationally. They apply very narrowly and they aren't something that routinely we see businesses relying on for international transfers. So they're sort of they're kind of the third element that allows you to transfer personal data internationally, but I would say not relied on particularly often. So we won't spend too much time looking at those. So like I say, none of that's changing. Those kind of fundamental principles of international transfers all staying exactly the same. But what the Act does do is it introduces the new data protection test. And this is the test that's applied for assessing the standard of protection that will be afforded to personal data when it's exported overseas. So previously, when an organisation was deciding it wanted to send personal data to a new location that didn't have an adequacy decision, and it would be putting appropriate safeguards in place and assessing those safeguards, what it would be asking is, does the protection for data subjects under the UK GDPR, are we comfortable that that's not going to be undermined by this international transfer? Whereas now there's a shift and the new data protection test will apply instead when you're carrying out that assessment. And what that data protection test will require you to ask is the data protection that will be provided in that destination country materially lower than the standard of protection in the UK? Now, the aim of the change, and it does feel very sort of nuanced on terminology, but the aim of the change is to simplify the assessment for organisations. So the idea being it should be easier for an organisation to assess, is it going to be materially lower standard when I transfer this personal data? Now, organisations must meet that data protection test reasonably and proportionately. And the way that they will do that is by completing a transfer risk assessment. So like we say, we've already got this obligation to complete transfer risk assessments. So nothing's changing in that sense. It doesn't therefore feel like there's a significant change happening here. But what I would say is that as for some of the other changes, the DUA Act is really codifying things that are already in ICO guidance. So for those of you that are familiar with the ICO guidance on transfer risk assessments, a lot of this will feel quite familiar. And that's because the current ICO guidance on transfer risk assessments looks at whether there is an increase in risk to people's privacy rights. And actually it explicitly confirms that if there is no significant additional risk, then the transfer can go ahead. So in practice, the test that's already in ICO guidance would probably give a very similar result to this new data protection test. Now, like we say, data protection standards and assessments are not changing a huge amount as a result. And we know that transfer risk assessments are something that organisations struggle with quite a lot. It's something that most people grapple with, and we get a lot of questions from clients on them, and we end up supporting quite a lot of clients with completing transfer risk assessments. So for many, it's going to be quite disappointing potentially that the reforms don't go further in this space. But what I would say is we are still waiting for further guidance from the ICO on new international transfer rules and this new data protection test. So it may well be that there is some further guidance which makes that transfer risk assessment process a little bit easier for organisations going forward. So we'll keep an eye on that guidance. The final group of changes then that I wanted to look at is a selection of changes that have really been focused on innovation. First of these is around scientific research. So throughout UK data protection law, there's various provisions which deal with processing of personal data for scientific research purposes. And what the DOER Act does is it gives us a bit more certainty as to what does scientific research actually mean. And set out on the slide there for you some of the items that are now expressly covered by that scientific research definition. So any scientific research that's for commercial purpose, for commercial gain, we now have certainty that that is covered. Any processing for technological development, provided it has that scientific element, again, will be covered, as will fundamental or applied research, but importantly, it's got to, again, have that scientific element. And then public health research, provided it's conducted in public interest. So really, this just gives organisations greater scope and greater confidence to carry out scientific research which involves the processing of personal data, because there's a really clear framework in law as to say, actually what constitutes scientific research. Moving on to the next slide then, on the scientific research topic still, one of the bases for scientific research is going to be consent. So you'll find organisations will collect consent from data subjects to use their personal data for scientific research purposes. Challenges with this previously have been that when companies, organisations, groups, etc. collect personal data for scientific research purposes, they don't necessarily know exactly what they need to do with that personal data for scientific research. That's something that sort of evolves as they go through the process. Whereas under current consent requirements, their consent request has to be really granular and get really specific consent for what they want to do with the personal data. So the reforms are addressing this issue. And what they're saying is actually now data subjects can provide broad consent to the processing of their personal data for an entire area of scientific research. It doesn't necessarily need to be granular and specific. There are conditions to that, which I've set out on the slide. So that's only where it's not possible at the outset to tell them specific details about what the processing activities are. If the organisation has that specific information, that does need to still be provided in the consent form. The scientific research must be consistent with generally recognised ethical standards, relevant in that area, and also people must be given the opportunity to consent to just part of the research, not the full exercise. So effectively being able to kind of dip in and out of the bits they are and aren't comfortable with, not an all or nothing approach. And again, this is really aimed at innovation, technological development, and just making it easier for companies to progress in this space without being constrained by data protection law. And the final change to UK data protection law I wanted to touch upon are the changes to automated decision making. Now, these are particularly relevant for AI technologies, which, if used for decision making, absolutely constitute automated decision making under data protection law. So previously, automated decision making could only take place in specific circumstances. So where it's necessary for a contract, if expressly permitted under UK law, or if you had data subject consent. Now, the DOER Act is removing all of these restrictions, provided that the automated decision making involves personal data, which is not special category data. But organisations will still need to put in place appropriate safeguards for the automated decision making. So important ones being making sure you've got time or opportunity for data subjects to request a human review of that automated decision. And also really important, of course, that you've got a lawful basis for the processing. But ultimately now you can sort of take your pick from any of the legal bases under the GDPR. You don't have to stick to those kind of restrictive areas that you did previously. So legitimate interest, for example, is going to be quite a flexible lawful basis for organisations, and where you can prove that you've got a legitimate interest, you can then use automated decision making with non-special category personal data. And again, just a word of warning, where you are dealing with special category data, those restrictions that I mentioned at the start, they do still apply. So there is that kind of higher level of care when we're dealing with things like health data, ethnicity information, that sort of thing. Now, our focus today has very much been on the DOER Act and how that's reforming UK data protection laws. And that finishes our sort of summary of those UK data protection law changes. What I want to do is just leave on this final slide for you a quick summary of the wider changes under the Data Use and Access Act, just so that you're aware of them. So smart data schemes, this is building on the open banking, the success of the open banking regime, and it's going to be targeting specific sectors like financial services, energy and telecoms to roll out similar smart data schemes. Digital verification services, effectively making it easier and more efficient for people to verify and validate their identity online. Information standards for health and social care, updating the rules around these. And then finally, AI and copyright, which was actually the point that meant that the legislative process for the Act took a little longer than we'd hoped, and it was the point that went back and forward between the House of Commons and the House of Lords. How they've dealt with that is saying that within 9 months, the Secretary of State must publish an assessment of the economic impact of the 4 options within the consultation. So we're going to be keeping a close eye on that one to see how that one plays out. Thank you very much for joining us. If you've got any questions, we'll leave our contact information on the slide there for you. Do feel free to reach out to us offline. We do also offer bespoke data protection training. So if there are any particular areas we've covered which you think, you know, that's really interesting or really important for our organisation to get a bit more information on, just reach out and let us know. And that's something that we can look at with you. Thank you very much for joining us.